this week we're joined by Paul Darling, OBE QC. Chambers and Partners describes him as magnificent, a superb advocate. If you have a tricky case, you'll want to go to him. So a little his background, he's established a formidable reputation as an advocate in all types and levels of tribunals all over the world. He specialises in complex cases which feature multiple parties, large teams and high volumes of material, and is often brought in by clients at short notice late in proceedings. He has an ability to work with colleagues from any jurisdiction and to grasp detailed strategy and tactics. He has allowed him to develop a practice which has taken him to every major jurisdiction, appearing in a wide variety of construction, energy and commercial matters. And just over a week ago, Paul acted as in the first ever entirely remote technology and construction trial in English legal history. So we thought it would be a great chance to have a chat with him. But first of all, we're going to start by taking a look back at kind of some of his career, because Paul, you started practicing in the 80s. So it'd be great to kind of find out a little bit about what the world of chambers was like back then.
Well, I joined what subsequently became Keating Chambers in 1985. Those were the days of the true construction law greats. Donald Keating was still alive and at the height of his powers. Anthony May was probably one of the leading advocates of the construction bar. There were some young whippersnappers, John Uff and Vivian Ramsey. John Dyson was again at the height of his powers. It was a very different world in those days because it was all done much more on the hoop and much more day to day. For example, there was no such thing as skeleton arguments. There were no such thing as hearings for bundles for hearings. What happened was that you were given a set of papers, perhaps on a Thursday afternoon, for a Friday morning hearing. You know nothing about the case at that point. You had to get it up overnight, go along and then talk to the judge and explain what it was all about. He would have a sort of miscellaneous bundle of papers. I remember one marvellous day when Barry Bridgman, who is my then senior clerk, to whom I owe all of it, legendary man, coming into my room one Thursday afternoon and saying, "Here are your papers for your application tomorrow, sir," because that's what they said in those days. And I said, "They look a bit of a mess, Barry." And he said, "Yes, but don't worry, it's only a strikeout." And I said, "And how much is the claim?" "Oh, £6 million, 1985, don't forget." And I said, "These papers don't look complete." And he said, "No, I'm afraid not, sir. The rest of them are in Mr. X's garage, and they're currently being sorted out by his wife." Now, that was an extreme example, but nevertheless, it was all much more oral, all much more short term. We didn't have witness statements. They were just coming in. They were TCC, or the ORs as they were then called, were starting to order them. We didn't have experts meetings. Cases went to trial and very often settled on the first day at the door of the court, which had been the plan all along on both sides. So it was a very different world to the world that existed even before COVID-19.
Wow. And what have been the main changes you've seen over the decades?
Well, the main changes have been, obviously, the change in the CPR to change procedure dramatically. Secondly, the requirement that things are properly prepared and that there are bundles. And thirdly, that there is a much greater use of skeleton arguments. And as I say, in the 80s, they were things that you didn't do. I remember the first trial that I was involved in as a pupil, being led by the great Patrick Garland. Overnight, after the evidence finished, we did a written, and when I say written, I mean manuscript, closing submission, which we handed to the judge. And that was thought to be revolutionary, putting a written document into the judge, even one in manuscript. And my handwriting wasn't very good, so I had to work quite hard to do that. I think that's one of the biggest changes. In our world, of course, if we're looking just at the courts, obviously adjudication having taken over from arbitration is a massive development. But in the courts, I'm afraid to say that the biggest development has been that we've now got very good High Court judges dealing with High Court cases, rather than the more variable quality of official referees and TCC judges. So I think it's all improved and got to the better, but it's all much more formalised.
Okay. That's really interesting. So looking at this TCC case, because it's been a landmark and could really change the way things handled in the courts going forward. But initially there was opposition to it being held on Zoom. What were your thoughts on
Yeah,
that?
I was leading a member of 39 Essex called James Burton, who is commercial and environmental and planning lawyer, and he was absolutely first class. He dealt with the application to adjourn because I was at that stage in bed with COVID-19. So I don't have all the details on to my fingertips, but I think the two principal reasons were, one was the internal burden on the defendant, bearing in mind all his other public duties, which the judge found was not an insuperable objection. And secondly, I think there was concern as to whether or not a technical trial of this sort was capable of being done remotely. And that was an application heard in early April. So I think the courts had not got their act together. Obviously, the commercial court was gearing along in parallel, and Justice Tier has done a couple of trials, and Judge Pelling has done an awful lot in the circuit commercial court. But at that stage, there was a fair amount of uncertainty about whether these sorts of cases could be properly and fairly done, and the level of understanding was, I think, very low. But the judge, Mrs. Justice Jefford, decided that to go with it. She thought that in all the circumstances, my clients, the claimants, had been waiting for a long time for their trial, and she decided that it was that it was going to be done remotely. I think at that stage there was a big mood in the civil judiciary at High Court level. I think there's an important to stress that the criminal judiciary is in a different position, and in the county court the position is different still. But the civil jurisdiction in London, particularly to begin with, was very much, we have to find a way to keep these cases being tried, and therefore Mrs. Justice Jefford refused the application to adjourn and ordered that we get on to have the trial, which we then did.
Okay. And for those watching and listening who might be thinking, oh goodness, what if I have to go on a remote trial? What were the practicality like? Who set things up? How did it work?
Yeah, okay. That's I was instructed by someone that many of you will know, Bill Barton of Barton Legal. And he and his team did a fantastic job. He had, lucky enough to have a fantastic trainee called Sanjida Begum, who was brilliant. The first thing that he did was establish which platform was going to be used, and we used Zoom. The judge had suggested Sky for Business, but we'd said we prefer Zoom, and that was discussed with the other side. So the first thing that has to happen is that somebody, probably the claimant's solicitor, has to grasp the process and set up how the details work. Second thing he did was to employ and retain a trial coordinator, a tech person who was going to run the trial and admit people to the courtroom, keep them in the lobby, deal with connection problems. Rachel did that for us. So retaining a practice to do that with somebody who was good had to then be set up. We then had to discuss the bundling and documents, and perhaps we might talk about that in more detail a little bit later, because I think that is a big question. We had then to get it all set up and everyone on the understanding what's happening. Then you had to do some trials to begin with. Whether I want to do a trial next time around, I don't know, but certainly for me, one of the big questions was having the confidence it was all going to work. It's nervous enough starting a big trial. If you're terrified that technology is not going to work, then that's one more distraction. And I think that confidence in my part certainly grown. I was logging in on my own by day 5. But early trials to make sure people understand what's happening, and also that all the witnesses are then geared up, clients, that the experts understand how it's working, just ensuring that there is a level of knowledge and confidence, and dealing with things like announcing it to the press, because it's meant to be a public court. We might have to talk about that in a little bit more detail later, because there are quite a lot of issues there. But basically, the key thing was to get a grip of it. And that's what happened in our case. And it happened very successfully.
I think that's been quite similar with all of us moving to technology, testing systems, and then getting used to how they work. And I think now we seem to be a little more familiar. It's not going to be so scary, hopefully, going forward. How did cross-examination go? Were you worried about how different it would be not being face-to-face?
Yeah, I mean, okay. First point to make there. Obviously, I must talk about a case that I was in with some care, but I had it settled. The terms were agreed between the parties on day 5 or 6, that sort of time period. By then, I had cross-examined the witness, a witness, for just over a day. My client had also been in the witness box, so I saw about just under 2 days, perhaps a day and a half of examination and cross-examination. First point to make is that if you are cross-examining a witness at all, but in my view, particularly remotely, you've got to have the documents in a state or order that will enable you to do so without interruption, without having to go to this bundle or that bundle. If it's electronic, in one sense, it's even more difficult because you've got to click between various different PDFs in various different parts. So what I did in this case, the documents were in a very good state, but I decided the way that I was going to best be able to deal with the witness was to prepare my own mini bundle of documents, referred to in the trial as Mr. Darling's bundle, which kept on making me smile. And I personally abstracted all the documents in a fair run. I wasn't trying to pick the ones that I was just using, but the ones that were relevant to the issues I was going to ask the witness about. I numbered them myself, ran them through the copier, agreed them with my opponent, or agreed the process with my opponent, and they were sent in hard copy to the witness. So the witness that I was cross-examining had in front of him a couple of bundles, one of mine and one other that I decided not to replicate. But he had 2 bundles, which meant that I was able then to ask him questions without the flow being lost. Now, that's good practice, in my view, cross-examining anyway, because you want the flow. It's one of the ways in which you achieve the objectives of your cross-examination. But in a remote one, I think it's absolutely central. And I think one of the big unanswered questions, I think it applies in real life as well, is how electronic bundles work with cross-examination. So I got round that by having these 2 small clips of documents. I mean, about 200 in total, 200 pages in total, that sort of order of magnitude. And I was able, by being by having got it all sorted out well in advance, the night before, I was able to make my cross-examination much more focused than otherwise it would have been if the witness had been saying, "Oh, which bundle do you mean?" So the first thing to do is to get your bundle organised. Second thing is that you've then got to be aware that it's a different environment. It's a different environment, and the witness, if the witness is at home, they are in a different situation to the one that they would be in the court. And that has a whole number of implications. Obvious one is that, and I'm not suggesting this happened in my case, it didn't, but I am aware of cases where it has happened, is that there is someone in the room with the witness who is able to assist them with the answers. In a case I've heard about conversationally, that is a factor. The judgment's been reserved, as I understand it, in that case, so we may hear something about how the court approaches that issue. But that's your second thing, is the anxiety that the witnesses may have assisted. And I stress, not in my case. The third thing, which did occur in my case, is that because you can't see the witness, or you can see them, but you can't see the environment around them, you don't know what else is in the witness box with them. The witness box is their kitchen table. And in our case, and I just report this without any comment or criticism or approbation, it became clear in response to some of my questions, that the witness was referring to a document. And that was a document that he, in fact, that had been prepared, I think, by him, as I recollect, to assist him in giving his evidence. Now, we only found that out because he referred to it, and he behaved perfectly properly, don't misunderstand me, there was but because we weren't physically in the room, whereas if he'd been in the witness box, you'd have known what he was going into the witness box with. So you've got all of those factors that are going to affect, even before you start the cross-examination. Now, I was very anxious that across a television screen rather than across a courtroom, that witnesses would be much more easily able to dissemble or avoid the question or whatever because of the lack of physical proximity. That, in fact, was not a problem in any of the witnesses that we saw, because, in fact, somebody on the screen in front of you is your physical proximity to them is, in fact, in many ways greater that there is, because of the technology, an appropriate distance greater than if you're across a courtroom. So I think myself that if anything, your connection with the witness is, and obviously I've only seen 3 witnesses do it, and they were all 3 of them doing their best to help the court. So I do think that the physical proximity issue isn't an issue. I actually think, some of you will remember these small courts in St Dunstan's House. I was doing a commercial case in one of the small courts on the ground floor, where counsels were in the witness box were physically next to each other, and so therefore, the counsel was just standing above the witness effectively, and there the proximity was too great. Whereas on screen, it gave you appropriate proximity, but which was visible and controlled. So I don't think that was a problem at all. You do get the talking over problem. I was told off by Mrs. Justice Jefford. She said it was only a request that I stop talking over the witness, but I was quite clear it was a bit more than a request. Talking over the witness because you not being in the same room and the judge not being physically able to act as the referee, witnesses could perhaps more easily just continue than you'd be able to try and bring them back to the question in court. But that wasn't a big problem, certainly with the witnesses that we had. I'd certainly not worry about cross-examining a witness over video link. I think I'd still, in many ways, for witnesses where credibility was an issue, prefer real life. That's perhaps a prejudiced way of putting it, but you know what I mean. But I certainly didn't feel any disadvantage through it being linked to, through it being by video rather than in real life.
Yeah, I saw an article a couple of days ago that said it was probably more terrifying for the witnesses than in real life. So maybe you're right. Yeah, maybe it's harder.
Yeah, I mean, 2 points about that. One is that the 3 witnesses who gave evidence were my 2 clients, who are individuals, and an officer of the council. I can't speak for the officer of the council because I was cross-examining him, but he did not appear to me to be any different to how a witness would have been in court. In relation to my own clients, I did feel that they were more comfortable and felt and seemed more at ease sitting in their kitchen with their daughter handing them the bundles. I did think that they may have been more at ease than they would have been in the hurly-burly of the court, because because of their own surroundings, but B, the start of a case in court, everyone milling around outside, someone bangs on a gavel or whatever, and the judge comes in, and so I do think that actually it may put witnesses more at their ease, which is a good thing.
Yeah. Absolutely. So you mentioned briefly about there could be some issues with people being able to log in and watch the case online. What do you think could arise due to that?
Well, I mean, first point is, I know, and I've seen a question in the chat box which talks about security in Zoom. We didn't have any problems with security. Don't know whether the extent to which Zoom's problems are a factor. And I certainly found personally a lot of the Zoom features very useful and user-friendly. But as I say, we had, and the judge was willing to allow us to use Zoom, even though I know there are security issues that in some cases. But this was a case that obviously one has to be careful about data in any circumstance, but there was no particular sensitivity about this case. Secondly, obviously, one of the things that the judiciary, the senior judiciary and the judiciary generally are concerned about is the prohibition on recording. So in order to get into the court, you had to sign a form online or tick a box online that acknowledged that you understood that you weren't entitled to record it, and that the various obligations that you would, similar to that which you would have if you were sitting in court. But it did seem to me that there was a real advantage here, because when I was sitting listening to my opponent cross-examine or making submissions, it was interesting to look at the attendance box, and there were a number of categories of people. There were a lot of those who were involved in the case, who, as one knows from these cases, some of them come on day one, but gradually by the end it's just you and the judge. But certainly one was conscious that there was a much greater accessibility of witnesses. Secondly, the experts were all keeping an eye on what was going on online, which I think is has great benefits, so that the experts are not remote from the factual evidence. Whether they would have come to court, I suspect they wouldn't, and would have relied on the transcript. So I think that the accessibility online. Thirdly, various of my clients' friends who'd been taking an interest in the proceedings were also able to watch. Others, I suspect, I don't know whether they were or not, but if you are a stakeholder in litigation, such as for example, the counsel, the chief executive, you would have the ability to access the trial yourself, rather than having to rely upon read and rely on reports. And of course, it was also accessible to the press. I certainly, of any trial I've done, of any of the normal trials I've done, this had a much greater attendance of people viewing it than anything I've physically done in court. Because let's face it, most cases in court, the only people that are watching them are the work experience or mini pupils from solicitors and barristers' chambers. And apart from that, the public gallery is empty. So it did seem to me that there was an advantage there. I know people worry about the recording function, and in more sensitive cases that might be a problem. But for me, it wasn't in our case, because who would you play it to, for goodness sake? It's a bit like nicking a piece of fine art. You can't put it on the wall because everyone knows it's been nicked. You can't play extracts from court because you're in contempt. And frankly, I wouldn't fancy being that.
Yeah, of course.
I see also, Annie, as we go along, that there's the answer. The question is, was there a dress code? The answer to that is yes. The dress code is suits. Mrs. Justice Jefford made it absolutely clear that this was intended to be a courtroom, and we would behave as if it was in court. Now, in the TCC, we do our cases in suits, and the equivalent. It's right, I think. Obviously, one of the things, slightly odd things, is that every different division has a slightly different practice direction. The practice direction, but the rule is no robes. I don't know what they're doing in crime. My brother sits as a circuit judge, and I think he does a lot from home by Skype at the moment, and I think he's in a suit. So I think everyone is in suits. But the judge was very clear. This is a court. The fact that it is virtual is pure coincidence. She was, however, human about it, because she was sitting, I think, in her study or drawing room or lounge or whatever it was, and immediately behind her there was a picture, a watercolor or oil or something, and she said, before we start, because I know you're all going to spend the next however long looking at this picture, I'm going to stand up, show it to you all so you can see what it is. It is a beach in Cornwall or something. And now we've done that, can we please get on with the trial? Which I thought was actually a very nice touch.
Yeah, I think again, similarly, everyone's kind of getting a glimpse into everyone's home lives. We've got lots of questions coming in, but we'll race through the ones we've got planned, and then we'll come back to all the questions
Yeah,
at the end. If that's, but yeah, do keep sending your questions in. Just on the last question on this case, as virtual cases become more common, what do you think? What are your predictions on how things might change in the future?
Right. First point is that I think that there will be applications of under a day. I think that they are going, when it recovers, when normality recovers, still going to be done remotely. For example, I was asked about relisting a case in August and September where I may be doing something in Hong Kong, or not, as the case may be. And I suddenly thought, well, hang on, it doesn't matter because it could be done remotely. CCMC, it can be done remotely. So I think there's going to be much more of that. Judge Pelling tells me, who's a judge in charge of the Circuit Commercial Court in London, that there is, great enthusiasm for remote hearings, even if physical hearings are being offered for application. Secondly, I think that trials, forgive me for the little joke, but the jury is still out. I'm sure that I do think it was a bit slower than it would have been. I think it would have added, if the case had run, perhaps 1 or 2, possibly 2 to 3 days to the length, because it is a bit slower. Secondly, I think that it will depend upon how the technology develops. I'm aware of a High Court judge who decided to adjourn a trial so as not to have it electronically when he thought it was highly technical. I think that all of that is very much up in the air. I think it's also going to depend upon how the various systems develop. I mean, you sit there, and I was saying myself I was technically agile by being able to recite the various different platforms. For example, when I just throw it in, for me, Blue Jeans is the one that I find the easiest. I joke, but we are going to be into that sort of analysis. My own view is it is here to stay, but I think that there will be a pullback from it when COVID stops, and a sort of more principled evolution to work out what works well and what works badly. The one person who we don't know what they thought about this was the judge, because at the end of it, at the end of a trial, the judge has to go away and draft the judgment. And it'd be interesting in due course when there have been some judges a body of judges who've tried this, to find out how they feel about it, because one thing about advocacy is what you're doing is presenting it for the benefit of the court, and that is a factor that really needs to be fed in. So I think it will fundamentally change the way we do things. The other thing I would say is, and I don't want to be small p or big P political about it, everyone talks about the underfunding and under-resourcing of the court service, and I fully accept that there are serious issues. And I gather that resourcing is a big problem in the county court for remote hearings. I was anecdotally talking to friends and colleagues who tell me that a lot of stuff in the county court is just being adjourned off rather than put onto Zoom or Skype for Business or whatever. But it is pretty remarkable that the High Court and the Court of Appeal and the Court of Appeal Criminal Division and the Supreme Court, particularly the Supreme Court, have, even despite the resource issues, so quickly adapted to this technological world. The Supreme Court were trying hearing a 2-day appeal by Skype from home the day after lockdown, or 2 days after lockdown. So, I do think it's worth remembering that the court, this may have been the court systems shining out.
Yeah. Okay, before we take some questions, we're just going to quickly ask you, because you've got a new appointment as a non-executive chairman for the Horse Race Betting Levy Board. Do you want to tell us a bit more about your new role and what the future holds?
Yeah, of course. It's very much part-time. When barristers get to their 50s, or very often their mid-40s, they decide that they want to go off and become part-time judges. I'm not of that view. I don't want to be a judge. I enjoy being an arbitrator, but nevertheless, a judicial career for all sorts of reasons, is not for me. I don't fancy the distinction with which my friends, members of my old chambers, members of my current chambers, the distinction which they've all performed, I admire enormously. And I am married to the daughter of 2 judges. So, you know, judges are marvellous, but I just don't want to be one. So when they were all going off to do their recorder exams, I wondered, what could I do by way of equivalent? And the answer became to take a non-executive job in the horse racing industry. First of all, I was on the board of the Tote, which in those days was government owned. It owned the betting shops, the Tote, and the racecourse, the racecourse pool. I was then invited by government to swap that for a job 1 to 2 days a month as non-executive member of the betting levy board. I then, and I enjoyed that enormously. I then got the non-executive job that I most enjoyed ever. I was chairman of something called the Sports Ground Safety Authority, which was brilliant because it combined all my passions, construction of sports stadia, sorry, boring, but nevertheless, one of the things I'm really interested in, trying to do some good to stop Hillsborough recurring, and regulation. So circumstances that are too long to talk about on a short call like this, had a marvellous time doing that. That came to an end. I then found myself doing a small part of my time as the non-executive chairman of the Trade Association for Betting Shops. And those of you who follow the gambling industry will know that couldn't be described as a sinecure. And so that all came to an end in October last year. And I thought to myself, well, time for a rest, etc., etc. But then the government very kindly asked me to become chairman of the Betting Levy Board. And what we do is we receive levy that has been paid by bookmakers on winning bets to the levy board, and the levy board then distributes that money in the interests of horse racing and breeding. Happily, it's not a time-consuming job, and it doesn't get in the way with my practice. But I have to say, I prefer to sentencing people for criminal damage in South London. So it gives me the external reward without getting in the way of the practice. And as I say, the variety it brings is very useful. I have to say that when I agreed to do the job, I didn't realise that COVID-19 would cause horse racing to stop immediately. And therefore, this last few months, it's obviously been a little bit heavier than otherwise it would be. But hopefully normality will return and we'll be able to get British horse racing running normally as soon as we possibly can.
Yes, that sounds very exciting. So we'll take some of the questions now. Let's start with, where are we going? Let's start with this one from Chris Sunderland. He says, I remember the Court of Appeal case where Paul did where the tribunal were in Cardiff. My heart rate raised considerably when the old school dial-up link dropped out. Was that one of the first virtual hearings? Well,
of course, Chris, who is another of my old clerks, and in the same way as I owe so much to Barry Bridgman, who is in fact Chris's father-in-law, I owe a very great deal to Chris as well, not least for his calm in the sorts of circumstances he's just described. He's right. This was in the days when technology was literally dial-up. And I can't remember what happened, but I can remember what happened as it comes back to me. The hearing was meant to be in London. The Court of Appeal decided it was going to go to Cardiff, and I couldn't go. I was in London for something else, and therefore couldn't go. So Lord Justice Brooke, sadly, who died recently, but he was the judge in those days, and I think it must have been early 2000s. I think I was newly in silk. Decided, well, don't worry, you can hear we'll hear your submissions by video link. Now, it was awful, frankly. There's no point in pretending. It was a renewed application by me for permission to appeal. I was representing the Coal Authority, as I recollect, and those are very difficult applications to do anyway, because they've already been turned out in the days that before they were abolished. Very difficult, because they'd already been turned down on paper, and if they were in London, they would have been sitting there with their arms crossed on the basis nothing you could say would make any difference. So I do think that that was not an ideal experience. It didn't make any difference to the result, because short of jumping over the bench and sort of grabbing them, there was nothing I was going to be able to do to get their attention. But it was an uncomfortable experience, and I can still, because I was in court. It wasn't done from Chambers. You had to go to court, and the video link would then take you there. And I remember, I have to say, Chris was standing there, bless him, with sheer anxiety on his face. That wasn't a happy experience. And indeed, I was actually thinking about that when I was looking at some Court of Appeal stuff that was being some Supreme Court stuff that was being on the Supreme Court website, and just thinking, how different is it to my unhappy experience in front of Lord Justice Brooke in Cardiff?
It sounds terrifying. That was why I was smiling, because I saw that question on the chat. What's the most low-tech trial hearing you've ever had? I think it is that, but I think there is something to be said here, which needs to be fed in. I gather that an awful lot is still being done on the telephone. I have to say, I think that telephone advocacy is one of the most much more difficult than video advocacy. And I myself think that if the court system can, it should aim to make as little use of telephone hearing as it possibly can. Okay, that's interesting. And this one from Paul Patrick. What are your thoughts regarding cross-examination of experts, including having?
Well, characteristically acute question from Paul. Two answers. One is, I think that it could be better and easier because, and I think this is a separate but related issue, if you are able to use the document management system, I called it the screen save system, and the judge pointed out that I'm sure that was from the 1980s. It was in fact screen share, obviously. If you can use that to have the documents on screen and plans and maps and photographs, I think that cross-examining an expert could be easier. I think that witnesses will, however, and I don't intend any discourtesy to experts generally by saying this, witnesses will develop techniques, a bit like witnesses who are giving evidence through an interpreter, to protect themselves. And I think that is, with an expert who is giving evidence regularly, a danger. I myself would be sceptical about the moment, on the software and platforms as they are, about hot tubbing, because I think that physical presence in court, so the judge can identify which expert's speaking and stopping them with visual gestures, is, I think, more likely to be harder on video, harder on remote than it would be in real life. So I think there's a challenge with hot tubbing, which I think is, and certainly I at one point wondered whether we should be hot tubbing the quantum witnesses in our case. And when I did that, when I suggested that, my opponent wasn't keen, not because of the technology, just didn't think it would necessarily work for our particular case and issues. And one of the reasons I didn't push it was that I wasn't sure how the technology would work with it. So I think hot tubbing is a big challenge.
I think that kind of leads into this question, sort of, is it going to be more difficult to keep track of witnesses and judge facial expressions and reactions?
Yeah, I mean, I think it's certainly harder to make people react and behave by the way in which you interact on the screen. Mrs. Justice Jefford did a first-class job in our case. She kept a very strict but nevertheless light-touched control, and apart from me talking over the witness, and actually then said sharply, "You're now talking over me, Mr. Tarling." So that was a tricky moment. But so I think that is a problem. But on the facial expressions, there is a real issue, because if it's on Zoom, you've got everyone's face on the screen. So and you're also much more mic'd up than you would realise. And indeed, I said something under my breath at one point, which in court would not have been heard by anybody, but was reminded by the judge that my microphone was on. But because you can see their faces, you can see much more going on, and obviously you're dotting between them. And you know, at one point an answer was given, and somebody laughed loud, and that had a much greater visibility than it would have done otherwise. I do think that when you are on single screen and just addressing the judge, I do think that you do not get quite the nuance of understanding the judge's facial reaction to what you're saying. I'm not suggesting that you don't get any, but I think that when you are making submissions, one of the things I hope I pride myself on is that when I'm making submissions, when I'm cross-examining, I listen to the answers, which is the key. When you're making submissions, you're listening to and watching the judge. And I do think that's a bit more difficult remotely than it would be face-to-face. And
okay,
the answer is
probably...
be aware. The answer is be aware of the fact that you're always, for future improvement, you're always visible and more visible than in court. And secondly, that you are that you do need to make sure that you are using the technology well, so that if you're addressing the judge, you try and use the technology to ensure you have him or her on screen.
I think that's quite an important point, being visible, because that's one of the things a lot of people have been talking about, is this thing, Zoom fatigue. Did you find it more tiring being on camera all day?
The answer, I'm afraid I'm going to dodge that question. I don't know is the honest answer. Most of the 4 days I was on my feet doing the talking, and when you're doing a trial, when you're cross-examining a witness, your adrenaline, if you're going to do the job properly, has to be at absolute height. You may be controlling it, but nevertheless you have to be, and therefore, you know, I have to say I was exhausted afterwards, but I don't know whether that was the effect of COVID. But certainly I didn't feel tired during the process. The judge had breaks because the research suggested that it was, you know, more tiring than face-to-face. But the breaks, in fact, simply ended up being slightly longer versions of the breaks you have for the benefit of the shorthand writer. So I didn't think that was as big a problem as others. But I suspect if I'd been just sitting there watching, it might have been. But certainly, when you're doing the advocacy, you are literally on fire about it. Tiredness doesn't come into it.
Okay, and this is probably our final question before we run out of time. Given the practical advantages, do you think it would make it more likely that live streaming in some form will be allowed in court in the future?
Well, I don't pretend to be an expert on the regulations or the judiciary's views about streaming, but if you think about it, the Supreme Court live streams everything. Secondly, if there's any sort of public inquiry or matter of that sort of any prominence, it has live streaming. I understand why in criminal cases live streaming gives, or recording or broadcasting gives rise to all sorts of issues. But I have to say, I struggle with what is the objection as a matter of principle to live streaming of civil cases. They're meant to be an open court, access to justice. So my own view is that they are good things. Streaming is a good thing and should be widely encouraged. I make no bones about it. I myself will often watch the Supreme Court. I'm going to be there myself in November, and one of the benefits of it being live streamed, or the Supreme Court being live streamed, is you can watch and learn. And I learn massively from having the Supreme Court on the background and watching other advocates doing it. And the same would be true for cross-examination, because there is no, I know that there are teaching methods, but there is no substitute for watching the great people in action. Now, obviously, the great cross-examiners, many of them are criminal silks or juniors, but I do think live streaming would be really good for training and for access to justice.
Yeah, I think that's true too. Sorry about the noise there. I live behind the fire station, so the fire engines just went off while you was talking. I think that's all we've got time for. I'm going to hand over to Stu, who's going to do the thank you so much, Paul, for joining us.
No, good to talk to you, Annie. Good to talk to you.
So thank you, Paul. I just wanted to dive in and gate crash Annie's session with you and say thank you to you. Thank you to everyone who's joined us over the last 10 weeks. As I say, we are going to drop back to doing these once every fortnight now rather than once every week, because they do take up quite a lot of our time. So thank you all for coming along today. Thank you for listening. Do join us in 2 weeks' time when we're going to be having our delay analysis debate, argument, fight, whatever you want to call it, with 3 delay experts. And yeah, thanks again, and thank you.
Just before you depart, could I just say one thing?
Yeah.
Because this is such a new thing, everyone is obviously very interested in it, and I'm perfectly happy if anyone has any specific questions that they want to, or advice they would like on it. If they want to email me, my email address is paul.darling@39essex.com. More than happy to hear from anybody if I can help.
And the other thing I perhaps will mention while we're here as well is that you have another webinar. If people are really keen, you've got one with Bill Barton coming up, haven't you? That's
yeah. Bill and I are going to be doing a chat tomorrow, where he'll explain more of the practicalities than I was able to. So it's on my LinkedIn page if anyone wants the link. It'll be a different event. It'll be at the risk of making it sound less attractive, much less about me.
Okay, thank you very much indeed, Paul, and thank you again to
Paul.
everyone. Cheers. Goodbye.
Goodbye.
Thanks very much.